Yes.
My Lord, two preliminary matters. The first is that so far as we've been able to establish, Greenpeace did bring a claim to the NPS approach to nuclear energy in 2011. And it was refused on paper. We're not aware of a renewal, but we don't know either way, if I can put it that way. So there might have been a renewal, but we're not aware of one.
Okay, thank you.
And the second matter was paragraph 69 of the judgment below. I have checked the EIA regulations, and Mr Justice Holgate is correct. There is no definition of a project. And I think, in fairness, if I'm allowed to say that, to what he's observing there is that he's focusing on the word project specifically because it's used in the habitat regulations. And he's pointing out there isn't such a definition to be found in the EIA regulations or the HRA, or the, habitat regulations.
Right.
And then can I complete my section 2 on legal principles? And my Lord, first additional point, the mere fact that two sets of proposed works may have a cumulative effect on the environment is not sufficient to make them a single project. See, Lord Justice Sales then was in Larkfleet, the Larkfleet judgment at paragraph 36, and that's tab 17. I wasn't necessarily going to take the court there, but I'm just making that observation based on that authority.
Yeah.
The next legal submission, my Lord, is that when dealing with project splitting or salami slicing, however one likes to put it,
they're the same thing, aren't they?
the same thing, but they're described differently. I was trying to find out the origin of salami slicing in this context. So far as I can tell, it's Mr Justice Sullivan in the Chew and Milne case, Rochdale, where it's that's first reference we can find it.
First referred to in one of the European cases, but you may be right.
It's subsequently picked up by the Advocate General. I'm going to show you that in Commission against the UK, but that's afterwards. Yes, I think she may. Where it emerged.
Wasn't an Italian judge by now.
Possibly. Yes. So, but that aside, the when using this term, whichever term one uses, the authorities have made it clear that one does need to focus on what it's directed at. And Lord Justice Laws in Bowen and West, tab 10 of the bundle of authorities, paragraphs 32 to 36, and again, I don't necessarily need to turn it up, but just point it out to the court, makes that point that salami slicing and project splitting, the vice originally was about avoiding the regulations altogether.
Yes, there is a deliberate element to it, I think. It's inherent, I suppose, or implicit in the word device, but it is the attempt by the developer to avoid the rigors of assessment by dividing the project.
Yes, and that the reason or the observation made by Lord Justice Laws is that it's therefore a fallacy to take all of the jurisprudence on appropriate assessment, for example, or EIA, and apply it as if it's automatically applicable to all EIA cases, if what you're dealing with is the question of avoiding the EIA altogether. Yeah. And a good case in point here would be my learned friend's reference to the principles in Champion about what one needs to do if you're carrying out an appropriate assessment, the precautionary principle, none of which is in dispute. But it doesn't mean that taking that principle, precautionary principle, somehow means that when you're making a judgment as to whether there's one project or two projects. One has to apply a precautionary principle there in the same way, or making an assessment is somehow not subject to Wednesbury rationality in this court, for example. So that's the only caution I express. I think it's fair to say, however, that the courts have still expressed and recognised that there can be concern if you do produce an environmental statement, for example, but you then don't consider the cumulative effects of it, of the proposal, because you're artificially limiting what you're assessing. A good case in point there is Brown and Carlisle, and of course, a case the other way was Littlewood and Bassett law, where there was an ES produced, and the criticism was it should have looked at the wider development of the area that was being proposed, and not simply phase one. But Sir Michael Harrison there said, well, no, because you didn't know what was coming forward. So those are two cases, both of which there was you hadn't avoided the rigours of the process altogether, but in applying EIA, and I would say by application of the same principle, HRA, you can't artificially limit what you then assess. So we don't have any difficulty with that. But what, in my submission, those authorities are getting at, and this is the foot in the door by Lord Justice Sales in the Larkfleet case, is artificially limiting either the application of the process itself or within the process limiting what you ought properly to be assessing. But what does emerge very clearly, and whether or not it's a touchstone, I don't know, but certainly does emerge clearly from the authorities, is that there is no requirement, and indeed it may be impossible, to assess those things where you don't have sufficient information, because you can't have that information. That's not project splitting or salami slicing. To the contrary, that's a legitimate application of either the EI regs or the habitat regulations, of recognizing that there's a limitation on the knowledge at that point at which, in the consent process, you're considering the development in question.
Yeah, and this isn't the same thing as artificially splitting the project so that you avoid assessment. It is genuinely not knowing what the second project is.
Exactly. And my lord, that there's been a lot of time exploring the authorities for the facts, on the facts. But it's, in my submission, a fruitless task. You can obviously see what happened in different cases on different facts. It's not going to ultimately assist the court in judging the rationality of the Secretary's assessment in this case on the facts, absent some misdirection as to the approach, which no misdirection is being identified. And that point, if I may respectfully say, was the point made in the Ashchurch judgment at paragraph 80. The Court of Appeal there made it clear that these are fact-specific cases. And like many of these areas, lengthy exploration of authorities to see what happened in one case and what happened in another is really a waste of time, if I could put it shortly. The paragraph 80 of Ashchurch. But the proposition I did derive about project splitting and salami slicing can be seen by reference to these authorities. So I've identified Bowen and West, which makes the point about where you need to be careful about the case. You were taken to Preston New Road Action Group
Yeah.
in the Court of Appeal and your Lordship's judgment in that case. And my learned friend took you to, in effect, the fact-specific parts of that case. But actually, the relevant parts of the case, in my submission, occurs at 64, paragraphs 64, 69, and 75. That's bundle 18, tab 18 of the bundle of authorities. Because all that is being flagged up there correctly or consistently with the principle I've just expressed is you can't assess those things which you don't know about.
Or which you could know about, but you're not necessarily going to do, because Mr. Bull's second point is you could know everything you need to know about the desalination, but you say yes, but you
Well, it's not part.
that's
It's
what
not.
you're going to do.
Yes, it's got to be part of the, in effect, the proposal.
It has to be something that is likely to happen for it to be even capable of or worthy of assessment.
My Lord's exactly right. It's got to either be part of the proposal, screened with an eye that someone's not artificially excluding something. So in that sense, but the permanent desalination part in this case wasn't part of the proposal, and the Secretary of State was entitled to say, I'm not going to treat it as such and not require an assessment.
It's not because no information could be made available, it's because it's not likely to be, or is not currently thought likely to be the option. There's no point in assessing.
It's not what's effectively being proposed as the likely scenario. And of course, the language of likelihood is not entirely irrelevant in this context, both for EIA and for habitat regulations assessment. This isn't an exercise in an obstacle race, as I think it's put elsewhere in some of the authorities, where you have to climb every obstacle, even though you're dealing with things which aren't in prospect. And just for completeness, again, in the Wingfield case, Mrs. Justice Lang also cited the Burn and West passage in dealing with that case at paragraph 51, 60, 61, 63 and 71 are the relevant parts. And so,
60.
sorry, the relevant parts dealing with this the difference between
51, 60, 61.
60, 61, 63 and 71
Thank you.
passages, sorry. So, I'm so sorry. I think that's right. That's right, yeah, according to my note.
Okay.
And then, so when you were taken to the Brown and Carlisle case, which is one of the authorities that went in additionally, that is on the facts, an obvious case in the analysis where what was being identified for ES purposes had taken out of it the airside development which had previously been in the application before it had been called in. If you see the facts of the case, there was a composite planning application made for both airside development and warehousing, as the judgment records. That was called in by the Secretary of State, no doubt because it involved aviation, etc. And then a new application went in, just including the warehouse development. But then the planning authority relied on the benefits of the future airside development to make it compliant with the development plan. And what's more, imposed a section 106 requiring that to come forward. So it was just, you can analyse this, but it was an obvious case of project splitting or salami slicing according to the court. Ashchurch, in my submission, bears very close parallels with Brown and Carlisle on analysis. There wasn't a sort of preceding planning application, but the analysis there was, of course, that relying upon the benefits of development, in that case, up to certainly no less than 826 homes for which the bridge was going to serve in the officer's report, but then ignoring the harms, was just a straightforward, improper approach on sort of public law grounds of taking into account some considerations, namely benefits.
That was ground one.
Ground one and indeed two, exactly. But there was a parallel to Brown and Carlisle, which was that you were relying upon, you were purporting to assess only the warehouse development, but relying upon the benefits of the airside development, which you were requiring to come forward by way of Section 106. So it's again, these fall into the categories of project splitting cases, or salami slicing in that sense. And that feeds into the assessment then in ground 3 in Ashchurch as to whether or not you're complying with the EIA regulations. In both Brown and Ashchurch, the relevant authorities, the relevant planning authorities, didn't apply their mind to the question of whether that other thing they were attaching the benefits to was a necessary part of the project. They didn't even ask the question properly. And that's hence why both came unstuck. In Brown, the court did go so far as to say it would have been irrational to conclude that that wasn't an additional part of the project because of the Section 106. In Ashchurch, as we discussed, there were observations about whether it would be rational, but ultimately it was left to go back to the local planning authority to make a decision. So,
incidentally, in Brown and Carlisle, what was the where is the passage that actually articulates that point?
The rationality point.
Yeah.
That comes.
Oh, it's at the back of the bundle.
Yeah. It's paragraph 20. Sorry, paragraph 25. It's worth reading paragraph 25 in full because Mr Justice Sullivan was distinguishing the Davies case that reference was made because the correct question had been asked in Davies, is this an integral part of the project? And it wasn't asked in Carlisle. You see midway through, in the present case, there's no evidence that they ever addressed their minds to that question. But then you get the final observation, Mr Justice Sullivan, at the end of that paragraph.
Yeah, which is actually, is it strictly obiter? I'm not sure. Anyway, the decision was quashed on the basis that they hadn't directed their minds to the question.
I suppose I think there was a argument about discretion actually, so maybe it was necessary to deal with that. EIA discretion, paragraph 32.
Yes, had the committee considered that question, an affirmative answer would have been the only rational response, the corollary of which is that to reach the opposite view was irrational.
And so it's another case where, in fact, Wensbury rationality is being used by the court to assess the lawfulness of the approach on assessment of what the project is.
Right, thank you for that.
And so that's really what I was going to say about most of the authorities, really to say, well, where do they take you in this particular case? Beyond that, what I just want to touch on the Forest of Dean, because that is actually perhaps the most pertinent case here, because it's dealing with habitat regulations and the potential for a multi-stage consent process. That's at tab 14. You've already been taken to the judgment itself, but and the facts. And I don't, as I've said about all of these cases, my learned friend places particular reliance on the facts. I'm not referring to the fact. I'm trying to deal with the propositions that come from what Lord Justice Sales is identifying. This is about Spine Road and 2 development parcels. Well, the point of principle that's being discussed at paragraphs 13 through to 19 is about the application of habitat regulations. And each consent can follow sequentially without necessarily causing a problem at a later stage, provided, of course, one approaches the test correctly. Hence the observation of paragraph 19, which in my submission is entirely apposite as a point of principle to any case. It's not dependent on the facts of Forester Dean itself, namely 2 developments and a spine road, where the developments themselves may have been innocuous. Is it equally applicable in this context? But what
you
is...
say it doesn't matter, do you, that the 2 developments had their own separate merits and were not dependent on the construction of the spine road? Although that is mentioned as a relevant, it looks as if it's mentioned as a relevant factor in paragraph 19.
My lady, those were the facts.
Yes.
But it's a matter of principle.
Yes.
It doesn't affect the application of the principle that's being expressed. If...
Well, a principle is, I mean, here we're dealing with interpretation, but a principle is decided, which, if it's common law decisions, is applicable to those facts and other facts that are material.
Yes.
So 2 things would have to happen. 1, are the facts of this case different? 2, if so, what is the principle? Because just because it's different, it's an apple, not a pear, doesn't mean you deal with it as if it were a fruit.
Yes.
Do you know what I mean?
No, exactly. Well, the facts are different here. I recognise that. In fact, importantly, the way my learned friend characterised the facts as different has to be taken with a degree of caution, because the difference in the facts, he says, namely, this project is dependent upon a water supply, as I pointed out earlier, applies to all projects. So in a sense,
you say the difference of facts
doesn't matter
for a different for an application of a different principle.
Exactly.
You say it's been put forward to justify a different principle.
And that's because of Regulation 63. The language of it requires you to look at a consent. And what is, before we get to paragraph 19, just to make the point as to why this is a issue of principle, what Lord Justice Sales is doing is citing from the Commission in the United Kingdom case, the Advocate General's analysis in Commission in the United Kingdom. And you have that in the bundle of authorities. You may not need to turn it up, because the key points at paragraph 15 of Lord Justice Sales' judgment, paragraph 49 of the Advocate General Cocott's opinion, where in making that observation, the Advocate General's recognising that you can have multi-stage consent processes, expressly recognising that, and you can have effects as more becomes known about them considered at a later stage in the process with increasing specificity. And you'll get problems with that word. But as the subsequent stages progress. And that's entirely consistent with the tenor here of avoiding sclerosis of the system, which is what the judge below had said. You're allowed to have this incremental process where you don't know what's there at an earlier stage.
That's picked up at paragraph 18 of Lord Justice Sales' judgment.
It is. So that's why when we get to paragraph 19, my submission is it's not dependent on the facts, or in the way my learned friend says. It's a point of principle derived from Commission and the United Kingdom. And if you want to know the facts of the Commission and the United Kingdom, it's in the authorities, but I say the facts. That was a failure to transpose the directive into the 1994 regulations for land use plans, and indeed water plans is one of the issues. And what the court was identifying is that land use plans were themselves plan or projects which required HRA, and the United Kingdom's argument at that stage was, well, they are plans, but there's no likely significant effects because it's only the subsequent consent, the detailed consent, that causes the likely significant effect. The Court of Justice said, no, you still need to do the HRA at the earlier stage. And of course, that is now reflected in the fact that the national policy statements with which we're concerned were indeed subject to HRA. Yeah. It's part of a harmonious position, which brings me back to the point, we're not at stage 1. That's already passed. We're at stage 2, and then we'll be at stage 3 even before this power station comes into operation, at which point HRA again will have to be considered. And the details of what considered can be considered in the light of what's then known. So there is at least a consistency, a theme, or in the case law from the Court of Justice, in the analysis of it by Lord Justice Sales, in the Forest of Dean case, which doesn't depend on facts. Can I then just pick up on what was said by Mr Justice Holgate at paragraph 81?
Yeah.
And
we're putting the authorities away.
My Lord, you just had to come back to them in one, because the Willoney case is relevant in this context. So what Mr Justice Holgate referred to at paragraph 81 of those 3 cases that I handed up yesterday, my learned friend went to today, and it said that Mr Justice Holgate's in error in not identifying a requirement for habitat regulations at the earliest possible stage. That is not a valid criticism of the judge, and the reason for that is simple. What is being identified in paragraph 81, as can be traced in the second Wingfield judgment he's citing, and Adastral, Newtown and Swire, is a distinction between the EIA directive and the Habitats directive. The EIA directive, in recital 2, I'll take you to the Champion case where you can see it, actually has as a recital, namely an object, effects on the environment should be taken into account at the earliest possible stage in all the technical planning and decision-making processes. See Champion, paragraph 4, page 311 of the authorities bundle, where you'll see that recital identified. Yeah. There is no such recital in the Habitats Directive, as was being observed by Mrs. Justice Lang, and is being pointed out by Mr. Justice Holgate. There is a distinction there. So there is nothing in error in what's said in paragraph 81. And that is at least consistent with one difference between the 2 directives. EIA is a procedural directive. The Habitats Directive is what's called a substantive directive. What Mr. Wolfe then does is to say, well, look at Willoney, and well, can I just take the court back to Willoney, because it doesn't say what Mr. Wolfe says it says. In his skeleton argument, Mr. Wolfe says Willoney is authority for requiring HRA at the earliest possible stage. That's how he puts it. And he said that again. Tab 20 of the authorities bundle is the case of Willoney. And in distinction to the court's consideration of the EIA regulations and directive, see the judgment at paragraphs 82 to 90, which are on page 477, I think, probably. I've got my
476 to 477.
477.
I've got. There's a consideration of EIA and reference to earliest possible stage for EIA by reference to the court's case law commission in Poland. when it comes to the habitat regulations assessment, one goes forward, because the same question was asked about the habitats regulations, 140 on page 484, the bottom of 484. What the court says, quite deliberately in my submission, is at 143. It doesn't say they had to be carried out at the earliest possible stage. They had to be carried out as soon as the effects which the project in question is likely to have on the project are sufficiently identifiable. And therefore, it's looking at the substantive question. Do you know what your effects are on the protected site? If you do, if they are sufficiently identifiable, then it's at that stage you've got to assess them.
Well, you start with what the project in question is. So you identify the project, and then you look at what its effects are, and then you assess whether or not it's possible to work out what the effects of them are going to be for the purposes of the Habitats Directive. And if it isn't, you move to the next stage.
Exactly. It's exactly,
And if
and
it
that's
is, you carry it out.
and that's consistent with Commission in the UK, Lord Justice Sales analysis in Forest Dean, and now what's being said in Wallonie. It inconspicuously doesn't say as early as possible.
Well, I suppose the only way you get to as early as possible is this presupposes that if it's sufficiently identifiable, if it's not sufficiently identifiable, it won't be possible.
Indeed.
So when you get to the next stage, it will be as early as possible because it is identified.
And I'm keen not to get too caught up in the semantics of
Yeah.
what's earliest possible stage as opposed to sufficiently identifiable. The key thing is it's recognition. One might thought this is blindingly obvious, that you can't assess something
If you can't.
if it's not sufficiently identifiable.
Yeah.
But what you are allowed to do at that stage, see this case, is put them down the track to the consent stage that involves.
And you say what you can't do is say, well, something else is sufficiently identifiable, so you should assess that, even though it's very unlikely that it's ever going to form part of this project, if at all, because everybody prefers you to go down a completely different route.
That is exactly right. I.e. the permanent desalination plant here not being proposed, and therefore the Secretary of State exercising a judgment, I emphasise, in the Wednesbury rationality, saying, I don't think that's part of this project. If it proves to be in the future, brackets, extremely unlikely or unlikely, then you'll have to come back and give a proper assessment of it.
Yes, it's not, the effects are not sufficiently identifiable, not because you couldn't measure what the desalination plant is going to do, but whether that would be the effects of the project. Because you don't know whether, or indeed you hope not, that you'll be going down the desalination route. It's not identifiable for one of two reasons. You don't know the details, or you don't know if that is what is going to happen. Exactly.
And contrast that with those sort of more artificial type cases where someone does know what's down the track, namely airside developments in the Section 106 case, or a bridge serving 826 homes.
Yes.
You know what they are, and you can identify them. And in both the Ashchurch case and the Brown and Carlisle City Council, the court made the point that in both those cases, the effects could be assessed. They were known. You could assess 826 homes and the amount of traffic, and indeed it had been done.
They actually tried to do it.
And in Brown and City Council, it had been done for the purposes of assessing the job creation for the benefits.
Yeah.
So because they knew what was being contemplated. Here, not, except for something which isn't being proposed, namely permanent desalination. So that's what I wanted to say about Wallonie and considerable care about what the language is. And I said at the outset, we're talking about possibility. But in fact, in my submission, the Court of Justice approach is to talk about when things are sufficiently identifiable, if, to the extent there's a difference. I think that may be...
That's heading 2.
Yes. Sorry, the very final point is something I made an observation earlier. So far as ground 2 is concerned, an assessment of cumulative effects, I don't understand there to be any argument. sorry, I think it's accepted that that is Wensby rationality. But your Lordship's judgment in Finch, of course, is looking at slightly different direct and indirect effects, but that is a question of rationality. And Wyatt, of course, we looked at earlier. But I don't understand that to be in question, i.e., what is the Secretary of State entitled to make a judgment as to what cumulative effects need to be assessed? In our submission, yes. Is it rational? That's the question for the court. Section 3, the facts and the decision letter.
Right.
On the facts...
Just before we embark on that, have you and Mr Philpott divided the time between you?
Yes. I'm aiming to give him an hour.
Right. Fine.
So I haven't got much more to say. I may be giving him a bit more than that.
You've got until 3 then.
Yes, exactly. So, my lord, the facts. I referred to the judgment. The facts are very fully set out, not really in dispute. I just got to make a couple of observations about the way it's put yesterday. The first is the one which I've really emphasised already, but just with this additional gloss. The facts include an assessment of the Barsham pipeline, as I was already pointing out this morning. But there is a further point about that. Whereas the examining authority, in reaching its view, took the view that there was no cumulative effects assessment at all, because they didn't regard that assessment as an effective one, the Secretary of State has decided differently. And no challenge is made. Indeed, my loan friend said that was a matter for the Secretary of State. So when the examining authority was saying they weren't content because they thought it was one project and they didn't think they had a cumulative impact assessment at all, the Secretary of State does, because he's taken the view, Barsham pipeline, cumulative effects, no cumulative effects that are unacceptable. And it's in that context he's making his decision, and it's a factually different situation to the examining authority based on a different judgment. And the second point is about what appeared to be the germ of a new challenge being made to the Secretary of State's request for information after the examination. My own friend says the Secretary of State did exactly what the examining authority said, investigate further as to what status had been reached in relation to water supply. And the Secretary of State then sent the letter that you've got in the supplementary bundle that you were taken to post the examination. And that's page 104 of the supplementary bundle. And section 3 was the request for information about water supply. And the Secretary of State's request was, at 3.3, would it be possible for that temporary desalination plant, which was providing the temporary, which would be made a permanent one? Yeah. And that then set this line of inquiry off. You were then taken to the response from the applicant at page 109, you recall that, to those questions. And that starts on page 113, and you were taken to certain paragraphs of that to the effect that here the applicant was providing an explanation that they couldn't give an assessment of the NWL options, the water supply options via the pipeline, for the reasons it's set out in 2.1.1, page 113. But the submission was made, and those follow right through to 2.1.16, but the submission was made, and this has been a theme, that the applicant could, but simply just didn't answer the question as to the permanent desalination plant There wasn't an assessment being provided of that. You recall that. But that's not an entirely accurate summary of this. What the applicant, as was explained, set out was that the temporary plant couldn't be made into a permanent one. But they went on to say at 2.2.3, which is a passage my lady flagged up, in the unlikely event, you could actually provide a permanent desalination plant, page 118, 2.2.3. And then they discussed a permanent desalination plant. And you were then, I don't think we went through the passages at well, I think you might have done 2.2.5, 6, 7,
We did,
8.
because I've got it sidelined. We went through 8, certainly, and 2.2,
Well, there, so there, and over the page 2.29, 2.210, 2.211, the applicant says that they are not providing a detailed assessment, but their initial view was there wouldn't be any impacts on the marine or terrestrial environment if you were to provide a permanent desalination plant. See 2.2, 9, 10, and 11. So it's not fair to say they weren't providing any assessment. They're recognising it's not a detailed assessment, but their initial view was that there wasn't. And that must then be seen in the context of a bit which I'm pretty sure you weren't shown, at 2.3, bottom of page 120. This is the question: the information should be sufficiently detailed to enable the Secretary of State to reach a reasoned conclusion. The applicant comes back to deal with the NWL options at 2.3.1, 2, 3, 4, and 5. Then over the page, they cite Pierce, Larkfleet, and Littlewood. And then they explain at 2.3.9 the Water Resources Management Plan, the difficulties with providing assessment of those. And 2.3.10, they return to a permanent desalination plant in the context of the question that had been asked for sufficient material. They say, we're confident NWO is planning for the other solutions. Nevertheless, in the unlikely event that a bespoke permanent solution is required, we're aware that further detailed assessment would be needed. So they're answering the question about detailed assessment. They say you would need to have more information, but their initial assessment was there wouldn't be a problem.
And then 2.3.11 might be significant.
That's their analysis,
Yeah.
their initial assessment under the habitat regulation assessment. Without a full assessment, they're saying we don't think it's going to be a...
desalination.
Yes. So it's just wrong to say they were... the way it was put yesterday, or at least, I'm sorry if I've misunderstood it, was that somehow the applicant just ducked the question. They didn't.
Firstly, you say it's wrong, but secondly, say what? Because it's not a ground of challenge.
It's not a ground of challenge, the adequacy of this, but it appeared to be emerging as such. But they definitely did tackle the question, and the Secretary of State took into account what they were saying in his reasons, which is what I really want to go to now. Could I just invite the court to the decision letter? For my purposes, you could look at it in relation to what's in the... Well, I think it's better to look at it in the bundle, actually. Core bundle...
So 352.
Exactly, 352. And usual principles apply, reading it all, etc. It was an unusual approach yesterday to dot around from paragraph to paragraph because you don't actually get the sense of flow of what the Secretary of State's saying. But I'd invite you to read it in the order that the Secretary of State wrote it. And what the Secretary of State has done under the heading Water Supply of 358, paragraphs 4.12 all the way through to 4.28 set out the context of the information provided through the examination process. And just pausing there, it's a very detailed direction to the Secretary of State himself as to what the state of information about which no criticism is made. It's not as if he's misdirected himself or misunderstood anything. And then at 429, the Secretary of State takes the trouble to set out in detail what then happened post-examination in terms of all information about the state of play post-examination, which includes a full and fair appraisal of those responses that I've just taken you to, amongst other things, including in other representations received from other parties about that. C436. So, having received the applicant's comments, he also got comments from other interested parties at 436 objecting to desalination. 437, 438, 439, 440, 441. So he directs himself entirely correctly in light of everything that's been said about permanent desalination. You can see from those paragraphs, and you can look at the source material, everyone else was saying they didn't want permanent desalination. The notion that somehow in response to all of this, the Secretary of State should then write back saying, okay, well, no one wants this, but please go and assess something you're not proposing to build, in my submission, is just fanciful. And certainly, for rationality purposes, nothing can be faulted in this approach. And then 442, he asked for the further update between NWL, and then you get the subheading, Secretary of State's consideration of water supply. And I invite the court to read it all, obviously. However, can I just point out immediately that you are a world away from Ashchurch or Brown. There, the question wasn't even properly asked. Here, the question is being directly asked and addressed by the Secretary of State. What is the project and what cumulative effects need to be assessed? And then beyond that, we're into a sort of rationality challenge of what his judgments were. 443 was on construction, no issue taken about that. 444 was updating the position so far as the NWL options were concerned. 445, he directs himself correctly in relation to the policy, national policy statement on other regulatory regimes. 446 and 447, he directs himself as to what the NWL are going to have to do by way of planning guidelines when they produce their WRMP. 448, the policy itself says you may not know everything at the time the development consent comes forward. 449, having directed himself entirely correctly, no criticism made about all that, he reaches his conclusion that the WRM24 process, that's effectively the NWL solutions, the sourcing water, are separate projects to the DCO. And he says it's evident from separate ownership and asynchronous determination processes. And read with the preceding paragraphs, it's blindingly obvious what he's saying. Here's a different statutory regime run by a different water undertaker involving land which doesn't even belong to the developer, building a pipeline or any other solutions where the assumption is those solutions are going to be subject to their own regulatory processes. They're asynchronous, i.e. they're not going to happen at the same time. This is a reason for me not to treat them as the same project. All the court has to ask itself is that irrational? Answer, no.
It may not matter, but just for completeness, this is evident from their separate ownership. It could be modern speak for who's responsible for what, because we must now take ownership of everything. Or it could be referring to actual ownership, legal ownership. We may be talking about what you said this morning about the water people having to build on their own land the infrastructure. Which is it and does it matter?
In my submission, it's both.
Oh, I think
Well, ownership is
responsibility and legal ownership.
indeed.
Yeah.
There's no dispute, in fact, that the Barsham pipeline, 28 kilometres, would be outside the ownership of Sizewell C. They don't own all the land to.
No, but now that presumably does.
And but
everywhere they have a right to put the pipes over people's land.
the
They
statute.
be under their ownership.
It will be owned by other people. The statutory undertaker will have the right to construct a pipeline. It's one of the powers it has. But it's these solutions, and particularly at the end of the pipeline, i.e. at the River Waveney, at Barsham itself, that will be in separate ownership. So, but it's also ownership in the sense, in my submission, see the preceding paragraphs.
Yeah.
He's referring to the statutory process of a different undertaker controlling that process.
I just wonder whether that picked up something that was said in the letter. In other words, whether this can be read together with the letter which makes that point.
It certainly can. That's the letter that came from NWL,
Yeah.
because they set out.
Sorry. Perhaps I did mean that, or should have meant that. I meant the letter you were showing us just now.
They're in a sense they're consistent because the applicant was referring in turn to the NWL letter. The NWL letter I had in mind is in a supplementary bundle, which the Secretary of State had been referring to at page 75.
Yeah.
And they're the options that were being discussed. Do you recall I talked about demand management? You'll see that 276, paragraph 7, what NWL was saying for WRMP 24. They can't meet all of the requirements, so they're going to look at a demand management and supply side scheme, see paragraph 7. And what they're actually talking about, paragraphs 8A, B, C, and D, are all things that would take place in different locations.
Yes, no, I was particularly considering the use of the word ownership.
Sorry.
And whether that reflected what was actually being said to the Secretary of State in one of these letters. If we go back, I'm sorry, do you mind if I just take a moment?
Not of course. I think it may
back,
be in.
We go back to
Is it 109?
Supplementary Bundle 104, isn't it? You're taking us through.
Yes,
some of the
that's and the applicant's response
Yes, it's the response to that. Sorry.
it begins at 109,
That's it.
and the passages. I'm not. I can't say with any specific confidence at this stage that the ownership is referred to specifically there.
No.
It's the closest I can come is 2.1.16. On page 117.
Yeah, well, that would be the sense of responsibility.
Rather than physical ownership itself.
I don't want to be grim about this, but when you say ownership, and you said it means legal ownership, and I was obviously thinking, I own this book, it belongs to me and you can't take it.
Yes.
What land pipes, what is it that's legally owned that's referred to in this paragraph, if it refers to legal ownership rather than driver responsibility?
If it's legal ownership, the land required to deliver the pipeline is not in the ownership of Sizewell C, the applicant. It's 28 kilometres.
Ah, so it's not saying who owns, the WN owns the land. No. The point is it's owned separately from Sizewell.
It's exactly. It's going to.
I must admit that's how I read it, because I thought that I was looking at this all through the sort of perspective of a Wingfield analysis. And of course, when you're dealing with salami slicing, one of the questions you ask is who owns the different parcels of the land?
My lady, yes. I mean, I think the question of a broader concept of ownership has only come in through the judge's observation that he was referring to different
Yes.
statutory responsibilities. In my submission, it doesn't.
That's much better.
The Secretary of State's reasons referring to ownership, which is sufficient for my purpose.
If you look at 449, you have the reference in the third line to separate ownership, which doesn't say NWL's ownership. But then at the end, you have, given that NWL has a duty to undertake that process.
Yes.
So there are two, on the face of it, there are two different considerations. And separate ownership does mean separate ownership.
Yes. I think the legal ownership concept caught by the first observation, that last sentence of the same paragraph is alluding to the ownership in the sort of more colloquial term, or I say not.
Let's not strain the use of the word ownership. Or give it.
They're talking about different statutory responsibilities.
Or give it an over-modernised meaning.
I'm not going to.
The problem is, and I hate to be grim about this, you read the first sentence, I usually start with the first sentence, and it's referring to two things, the proposed development and the processes, the statutory processes.
Yes.
And then it says, this is evident from their separate ownership. There must be a reference back to the proposed development and the statutory process, and that's why I think it is modern jargon for responsibility. But it may not matter. There is something separate attaching to water supply provision as compared with Sizewell. Sizewell aren't responsible in any legal or statutory sense for the provision of water.
It's, as a matter of, exactly, as a matter of, I think, fact or common ground, neither the land that's required to provide the connection and the solutions is owned by Sizewell, nor does it have responsibility for delivery of that. So,
Right.
that's
I don't think we need to spend more time on that.
No, and 450, as was pointed out, then considers the question of cumulative effects. And what is identified impeccably in my submission is in effect, the sufficiently identifiable question. You can't know what the effects are of the ultimate solution from NWL's proposals. You do know that the pipeline can be delivered without effects, because the Secretary of State says that in these paragraphs. You don't precisely know what NWL are going to do by way of solution in feeding that pipeline, or indeed altering that pipeline. But because you can't know, you can't assess them cumulatively, or my judgment as the Secretary of State is you don't need to assess them cumulatively. 451 is identifying and I say impeccably, because what the Secretary of State is doing in 451, 452, and 453 is taking into account of what is known, namely the likely preferred option of a Barsham pipeline, and assessing it in saying there isn't a problem. See the applicant's assessment. But insofar as there's a question mark, C454, as to how that pipeline would be supplied, bearing in mind what's going on in the Waveney and the potential reduction, nothing is yet known about that, but definitively. But insofar as that does require any change, then there'll need to be a new updated assessment. And that's through 455, 456, 457. And 458 makes the point that the Secretary of State doesn't have detailed information as to route or specification, but he's got sufficient information about it to make a judgment. (459), no more specific details, and on through to 460, to a similar point. And if you set that in the context of the language I took you to, sufficiently identifiable being a perfectly legitimate basis for not treating it as either the project or indeed cumulative assessment, it's impossible in my submission to find anything irrational about that assessment. 461 deals with the permanent desalination plant, And there the Secretary of State fairly records the competing arguments that were made about that. See the references I've taken you. He decides midway through, he expressly says, I've not requested further detailed assessment, given that it doesn't form part of the proposed development, and the applicant's position is that a bespoke permanent desalination plant is unlikely to be required. He notes that they had said it wouldn't generate any new effects, but then also notes that people had said, well, they weren't going to rely upon permanent desalination, and there were competing views about whether or not it would be a good thing. 462, he notes the timing of when they were talking about permanent desalination, and things have moved on. 464 deals with temporary desalination having been introduced as a result of the water supply problem. He thinks the revised water supply strategy is reasonable to rely upon in light of that change of circumstance. And then midway through 464, the Secretary of State considers that if, contrary to expectation, the applicant were to seek to provide water from permanent desalination, that would require its own consent and subject to detailed assessment before it could proceed. And that, in my submission, is entirely appropriate analysis and lawful analysis in light of the overall position. And 464, chiming with the submission I made earlier, he directs himself about the site license point, because that's the ultimate control. This project can't proceed without the potable water supply in place. And then he summarises the position at 465, again, not an integral part of the application of the potable water supply. Nothing surprising about that in my submission. And then 466, in the unlikely event that an NWL can't find a solution, then yes, desalination, but you'll have to come forward with a consent and an assessment at that stage. I'll invite you to read all that together. Ground one, therefore, my short points, see the judgment, entirely correct analysis. There is nothing unlawful, irrational in the Wensbury sense in what the Secretary of State's taken into account in those paragraphs. The material considerations he's identified are material ones in law, rational ones. He's not required to take into account every possible consideration that someone else thinks is material. And he's reached a perfectly legitimate judgment based on those factors to conclude that these are separate projects. And I don't really need to say any more about that. If that is then right, that he's acted lawfully in concluding these are separate projects, then my learned friend is then has to fall back on an attack on the rationality of the cumulative assessment. The cumulative assessment here included the Barsham pipeline, which was all that could be reasonably known, but didn't purport to assess the cumulative impact of unknown NWL solutions as to how they put the water in the pipeline. How on earth could you? Don't even know what they are yet, but pointed out they would be subject to their own processes and cumulative impact assessment as and when they were approved. And there again is absolutely nothing irrational in that process. And the exchanges that were had earlier today are entirely opposite. That there is nothing in the habitat regulations assessment to preclude one postponing, if that's the right word, but dealing with the later consents stage, because you don't have the sufficiently identifiable information of a solution which is yet to be formulated by a different statutory undertaker, with the safeguard that the habitat regulations assessment will apply to that process as the Secretary of State identified. In the meantime, avoiding sclerosis of the system by granting the consent for the project with the likelihood of a solution which for a water supply in 2032.
A little bit quick there. I got as far as nothing in the HR to prevent dealing in a later consent with.
The separate, I forget precisely what I said, my lord, but the dealing with the effects of the proposal for the water supply.
Of the second
effects for the water supply in this case, but a different project. This is on the hypothesis, of course, that ground one is not correct. Ground two must be that they're separate projects. You're perfectly entitled to deal with that separately at a later stage. See Forest of Dean, Commission UK, and Welloni.
And there's nothing to prevent you in the habitat regulations, do you say, to prevent you doing the first project first, just because there might be something that will come out of the second project that, with hindsight,
provided the first project doesn't give the consent to cause the harm of the second project. And bear in mind, the second project, the harm that's said to arise hasn't been identified yet and won't be allowed to happen if it's too harmful. By definition, you're not giving consent for that. The DCO does not give you consent to build a water supply from Sizewell to an other location or to supply that water supply.
I was going to Mr. Wolf's alternative viewpoint, was that is there something in the habitats regulation which prevents you from leaving to the second stage, the assessment to the second stage, where if that were refused, with the benefit of hindsight, you might not have granted the first one?
No, my lord, and that's back to my point about we're not even at stage one now anyway because of the MPS, but the same principle applies at each stage. And I gave you some answers about that.
There's nothing to prevent the grant of stage one or stage two.
Or stage 3, 4, or 5, however many stages it may ultimately be.
Because you think there's a possibility, which you don't know whether it will or will not be the case, that something about stage 3 or whatever might have changed your way of thinking at stage 1 or stage 2.
Exactly. Right. I've trespassed into my own friend's time. So, my lords and my lady, unless I can assist you further, those are the submissions.
No.
Thank you very much, Mr. Strong. Yes, Mr. Philpott.
I'm reasonably confident that I shall be able to make all of my points before 4 o'clock. A lot of the points that I was going to have made have been dealt with, and I can start by gratefully endorsing and adopting the submission on behalf of the Secretary of State to repeat any of those.
Right.
What I have to deal with is one preliminary point, which your Lordship raised before the lunchtime adjournment about the source of the obligation to undertake assessment, both SEA and HRA, of the Water Resources Management Plan. We'll deal with that first. And then after that, I've got 3 main interrelated points to deal with. I don't divide them by reference to ground 1 or ground 2. They have relevance to both, and I'll seek to draw them out as I'm going along. So the preliminary point, as my learned friend, I believe, indicated, there are 2 sources. So far as the SEA responsibility is concerned, that comes from the Environmental Assessment of Plans and Programs Regulations 2004, Regulation 5. That's the obligation to carry out an environmental assessment during the preparation of the plan program, and then Regulation 63 of the Habitats regulations, simply because this is a plan to which those regulations apply. Yeah. If I can also provide a reference to where this is reflected in what's happened here. We have in the bundle a copy of the WRMP environmental report, supplementary bundle tab 22. I don't need to turn it up, but if I can give your Lordship the references, page 248 refers to the Regulation 5 requirement. Page 252 explains that the nature of the report is that it embraces both strategic environmental assessment, habitats regulation assessment, and indeed water framework directive and a number of other types of assessment. It's an integrated assessment in that sense. And then finally on page 272, paragraph 9.2.1, there is reference to the fact that insofar as individual measures that emerge from the WRMP process will require planning permission or development consent, they will themselves need to go through the process of environmental impact assessment and so on in due course. So it recognises that further stage. Well, that I hope has addressed the preliminary point. If there's anything in that, in terms of the copies of the regulations which you'd like to convey, we can provide them, but otherwise I'll assume that.
Could you possibly just give me that last reference again, please, Mr Philpott?
Indeed, is this to the reference within the environmental report?
Yes, one about if individual measures emerge
Yes.
which need planning consent, then you have another look at it.
It's page 272 of the supplementary bundle, paragraph 9.2.1.
Thank you.
Right, thank you for that.
So, well, if I turn to my three main interrelated points,
Yeah.
the first point, I've given this sort of overarching description. It's important here, given the nature of the challenge as a rationality challenge, to be very clear about the factual context and specifically where the possibility of permanent desalination fits into it. And if I can take as the jumping off point for this submission, I'll ask us an argument which, if one is looking at it in the core bundle, it starts at page 648.
Yeah.
And the part I want to draw attention to, I don't need to read it out, starts at page 650, paragraphs 10 through to 12, where we have sort of summarised the factual context, in many places by cross-reference, but to also make clear there that my client's strategy, the applicant's strategy for the permanent supply of water to the operation of the Sizewell C station was and is for NWL to provide a supply through the statutory WRMP process. That was the strategy, of course, that was presented to the examining authority at the examination. The court will have seen that the element that the NWL element of that strategy covers both construction and operation and various different elements of water use. But the NWL element of that strategy had to change during the course of the examination as a result of limitations put on the abstraction. But at all stages we were relying on NWL. By the end of the examination it was clear that we were relying on them delivering a supply through the statutory process. And that's why the examining authority's report, of course, focuses on that issue. It doesn't consider reliance on permanent desalination plant, because that was not an option that my clients advanced during the examination. It's not an option that we at any stage intended to pursue or are in fact pursuing. And as my other friend has pointed out, the possibility of permanent desalination only features in the factual matrix of this case at all because of the question that the Secretary of State asked my clients directly in the letter of the 18th of March 2022. And it might be worth just turning up that letter. So I want to slightly develop a point that my learned friend, Mr Storm, made a moment ago. This is at tab 10 of the supplementary bundle, page 185, paragraph 3.3. Because what the Secretary of State is asking there is seeking whether it would be possible for the proposed temporary desalination plant to permanently meet full water supply demand. Then there is the request for any further information to understand the strategy. And then 3.4, the information should be sufficiently detailed to enable the Secretary of State to understand, reach reasoned conclusions, etc., on the different permanent water supply solutions. So that 3.4 embraces both the possibility that is floated in 3.3 and, of course, the wider suite of possibilities. I'm going to come on to those in due course. But the desalination plant that is being referred to in 3.3 is the plant that is part of the application. So because of the change that's made to the application during the course of the examination, bring on board the temporary desalination plant, what's being asked here is, well, could that plant that you are proposing and seeking consent for operate permanently? Now that, of course, is a different beast. It's a different possibility to that which ultimately comes to be looked at in the decision matter, because in between that, the Secretary of State has a response, which, as my learned friend has pointed out, says, no, we can't do that. We can't take the permanent plant that we are proposing, and which, of course, we have assessed, but only on a temporary basis, for the reasons that are given. But it's worth going on to tab 11 and to the response letter. I just want to emphasise another related point in terms of the reasonableness of the decision that is then taken, not to ask for further assessment of this. It's already been made clear, I don't need to labour the point, but one of the key points that this response explains is that we don't think it's likely that we're going to need to go there at all. But in terms of the what a permanent desalination plant would involve, on page 119, 2.2.6 explains that on a preliminary review, there are at least 3 main alternative marine outfall infrastructure solutions that would be associated with a permanent plant. That could involve a new dedicated outfall further offshore. It could involve repurposing of the combined drainage outfall, and it could involve discharge via the main cooling water outfall. So just that element of it could take 3 different forms. It then goes on to explain in 2.2.7, there are also likely to be at least 2 main alternative marine intake infrastructure options to source the seawater for that plant. New dedicated intake and connection into the forebay for Unit 1 or Unit 2 to utilise one of the 2 cooling water intakes that will serve Sizewell C. So, pausing there, both the way that the outfall will be dealt with and the way that the intake will be dealt with are identified as being at large. There are a number of options that would need to be considered. And then over the page 120, paragraph 2.2.9, this refers to, initially, the different locations that the temporary desalination plant will be located during the course of construction, because it has to move during the course of construction to make way for what's being built. But it then says it's not, and this is halfway down the introductory part of that paragraph, it's not considered preferable to permanently retain the plant amongst the area of landscape restoration. That's where it ends up at the end of the temporary period. Therefore, Sizewell C Ltd would further consider main alternatives, including an underground plant, and then identifies where that might be, and placement on the Sizewell A complex. So not only is there still at this stage considerable optionality in terms of the technology, the infrastructure options that would allow it to operate, but also whether it would be underground, above ground, where on the site it might be. So when the Secretary of State in due course is explaining the decision, don't consider that it's necessary to seek further information, that's a very different factual context to the one where the initial question was asked. Tell me what I would need to know if you were to retain the temporary plant permanently. And that also, I'd say, is germane and relevant to the rationality of deciding ultimately not to require that further assessment.
Well, this is all about uncertainty, isn't it?
It is, my lord. It's the reason not to require assessment has to be understood in the context that this was looking at a very different thing. When the question was asked, it was about retaining something that was proposed, where it would end up.
And that's been in my mind. Certainly, I'm just assuming there's a thing called a desalination plant, and it's obvious where it goes and what it would be. But you seem to be saying it could be underground, it could be above ground, it could be in and out of all sorts of places, the intake and the outtake, whatever they call it.
Exactly.
So there isn't a set thing in the universe at the moment called a desalination plant for Sizewell.
Not at all, my lord. And that's why, if I can just then, we'll come back to the supplementary bundle, but if I can then just go to the relevant part of the decision letter. So this is in the core bundle of tab 20. And it's paragraph 4.60 on page 372. And over the page, at the end of that, paragraph 373,
Which page?
it's 373. It's a continuation of paragraph 460, which starts in 372. And it's the final sentence. If and only if the WRMP process fails to provide a solution, the applicant will have to consider its own permanent desalination plant. So it's not a question about retaining something that's already proposed. This is about having to essentially start afresh and ask oneself, okay, well, how do we go about building a desalination plant? Where do we put it? What infrastructure is involved? And so the Secretary is recognising that it's not a straightforward thing to do. One doesn't just say, okay, well, we'll keep it.
Well, ironically, if your clients had stuck to answering the question they were originally asked, which is it possible to turn the temporary one into a permanent one, and simply said no, and hadn't volunteered that, however, you could come up with a possible permanent one in some other way, we probably wouldn't all be here.
Well, that's as maybe. The view was taken at the time to try and be helpful.
Yes, exactly. But I'm not criticising you, but I'm saying that a narrow question was asked. You chose to be helpful to the Secretary of State by saying, well, if you're thinking down along those lines, we could possibly go down here. But here's all the number of various permutations that involves.
As I said at the beginning,
and it's not our preferred option.
Said, well, we don't rely on that.
No.
And one of the reasons, as we explained in that response, one of the reasons why we only proposed it on a temporary basis was precisely because we had confidence that that ultimately we would get our water supply through the WRMP process with NWL, with whom we had of course been working for a long time.
So just so I've got it clear and spelling it out very simply for me, so I've fully understood it, it's not simply a question of not identifiable because we don't know if we'll ever get to a permanent desalination project. It's not even you, or are you saying it's not even identifiable because you can't do what Mr. Wolf would like you to do and say what the adverse effects are, because you don't know where it'll be, above or below ground, where the water will be discharged into through the other outlets or into a special outlet, or how the water will get into the desalination plant in the first place. So it's just as uncertain, is it?
Well, we don't say it's just as uncertain, because there are more limited options.
More limited options, it's not just you don't know whether you get to it. Even if you get to it, you don't know what it'll be precisely.
It's far from
It's both.
straightforward. And that's also obviously relevant to the likely utility of the assessment and the reasonableness of requiring it in circumstances where we say it is not likely to be required.
So it's whether it will be the option, and if so, the nature and requirements of the option
Yes.
are not fixed.
But I advance that point primarily because I say it's relevant to the reasonableness of deciding, do I seek further assessment of something which is not proposed and is not what I had envisaged when I originally asked for that information in the original letter. One can't simply read from the letter to the decision letter without looking at the response in between. And what I say, standing back from this, is that in order to understand why, notwithstanding the fact that we said we weren't proposing it, we said it was unlikely, Task and others didn't want permanent desalination, the criticisms that the appellant makes focus so much on the possibility of a permanent desalination plant. The reason for that is because of the problems that it faces with its legal challenge if instead it seeks to address its two grounds to reliance on the WRMP. And
Let's take it another way. If it was your preferred option, wasn't enough information available, notwithstanding the possible different permutations?
Well, I don't say it would have been impossible to provide an assessment. Its likely utility, its the levels of uncertainty would of course have been reflected, would have had to reflect that significant uncertainty as to its form and its location. I don't say it would have been impossible. I do say it would have been a doubtful utility. And I certainly say it wasn't something which the Secretary of State was legally obliged to request in circumstances where it wasn't likely.
Yeah, hold on, it could have provided an assessment, but of doubtful utility because form and location uncertain.
Yes.
And reasonable for Secretary of State in those circumstances not to ask for it.
Yes. And a point I want to return to in my second point is as to what role that could have played in the decision. Have we done it? I want to come back to that, but I just I mentioned that point now. And well, the second point which I'm going to develop, I just highlight it as sort of part of the conclusion to the first point. As I've said, I say the appellant is effectively compelled towards the unlikely desalination option because of the problems it faces if it instead focuses on the actual strategy we did rely on. And the problem with that, and it's a problem I submit, but also arises from the examining authority's position, is that the logic of that argument, the logic of the examining authority's position, is that unless and until the WRMP process has become sufficiently advanced that a specific source or sources of water could not only be identified but also secured, it would simply not be possible to produce an adequate assessment of the proposed power station development for the purposes of HRA.
That's the sclerosis point.
That's the sclerosis.
Well, it's not just the assessment. I mean, if there couldn't be an assessment, there couldn't be a consent, and therefore you'd be putting stage one to follow stage.
And that's my Lord, that's the second point. And I want to develop that, if I may. This is the logic of the examining authority's position point. So I've articulated what I say the logic is. That's my headline for my second point.
Yeah.
And it's important to see this by looking at the examining authority's conclusions, which we have in the supplementary bundle at tab 9. And for my purposes, I want to start on page 100.
Sorry, you're now onto your second point.
Yeah, so this is my second point, which is the logic of the examining authority's position is that unless you allow the WRMP process to get sufficiently advanced that you can not only identify a source, but you can treat it as secured, you couldn't produce an adequate assessment, therefore you couldn't have a consent for the power station. And so, just before I go into the detail, of course, insofar as the appellant seeks to draw support for its legal challenge by saying, well, this is what the examining authority thought, it's important to keep in mind the examining authority was addressing WRMP and not desalination. But if one goes to page 100 in paragraph 7.5.7, this is where they bring the water issue into the context of the planning balance and what they say its implications are.
Sorry, page 100 and...
100, and it's 7.5.7 at the bottom of page 100.
Yeah.
The first couple of paragraphs, first couple of sentences, sorry, I don't need to read. I want to pick it up in the third sentence. Whilst the applicant and NWL express confidence they will be able to work together to develop a sustainable long-term water supply for the proposed development, at the close of the examination, there was no secured, hence my use of the word, permanent water supply identified. This means there's been no assessment of the potential cumulative environmental effect of the proposed development with any assured permanent water supply solution. It refers back to Chapter 5. They say they prefer the position of Natural England on this matter, but we consider even if they're two separate projects, the cumulative effects associated with it should be assessed at this stage. And then in 758, there is a recognition at the beginning that this is not effectively the applicant's making. But importantly, what the examining authority doesn't suggest here is that there's something more that the applicant could or should have done.
Except wait.
Except wait. There's nothing the applicant could or should have done at this point. It also recognises correctly the urgent need for the development and the problem of delay its position will cause. But it doesn't say that there is anything anyone, whether my clients, NWL, or anyone else, can or should do in response at this point to enable consent to be granted. Now, it goes on to say, we consider that greater clarity is required at this stage in relation to the provision of the permanent supply solution and consequential cumulative environmental effects. But it doesn't suggest that either of those things could be provided based on current knowledge. And then if I can finally go through to page 103 to see how this feeds.
Before you do that, that's one thing. Is their view irrational, or is it simply different people? This examining panel and the second stage are both rational bodies, and they've taken a different view. The first question is this view rational?
If I can take it in two stages. The first stage is, this is a question of, two questions of judgment.
Mm-hmm.
First judgment, is it part of the same project? Second question of judgment, if not, do we need...
Yes, the second part I'm concerned with.
And I don't attack this on the basis that it's irrational. I don't need to attack it. I just need to be able to show that the Secretary of State was rational in reaching different.
Yeah, and if the Secretary of State had come to this conclusion, i.e. he accepted the examining panel's view that even if the separate projects, we prefer greater clarity and we'd rather wait and delay rather than grant it now, that would have been rational. So it's equally acceptable solutions, and different people may prefer different ones.
Through the narrow prism of rationality on the two grounds that we're looking at here, yes. I don't say that there wouldn't be some other legal flaw in it in terms of understanding of the system. I'll come to that in a minute. But I'm not here to...
No, you say it's rationality, and either solution is rational.
Exactly.
It's simply that it's not legally required to go down this route.
Exactly right. Exactly right. But it's important to understand, they weren't saying there is a solution other than you have to wait. And that's where one comes to in the final recommendation on page 103. Paragraph 10.3.1. Halfway down that paragraph, the XA recommends that unless the outstanding water supply strategy can be resolved and sufficient information provided, the case for an order for the development sector is not made out. So there are two elements there reflecting their reference to secured, assured, resolved. They're looking for certainty as to what the source is, and they're looking for environmental assessment of it. And the implication of that is that the planning system must grind to a halt so far as the development of this nuclear power station is concerned, and in brackets, and potentially for lots of other types of development as well, if that principle is right, and wait for the WRMP. But we say that was wrong.
You say 10.31 is wrong.
Yes. And this comes to my point about whether there might be other grounds for criticising it in law, because the legislation, policy and guidance relating to the WRMP process provide the answer to those concerns. And we had set out chapter and verse on those points, first in our representations to the examining authority, and then, of course, we've drawn attention to those points to the Secretary of State, and we've gone on in the representations to the Secretary of State to deal with the question of EIA and HRA and deferring that to a later stage. We provided the answers, and I can just, for the purposes of submission, I remind the court that it's supplementary bundle tab 3. In particular, Appendix 1 to the submissions that we've made at the issues specific here in 11, where we've gone through the law and the guidance on this in some detail, precisely to explain the relationship between these processes. Supplementary bundle 5, and it might just be worth, if I can just draw attention to a particular point here, turning up this document. The document at Supplementary Bundle tab 5 is a written summary of oral submissions that we made at issue specific hearing 15. So this is one that came late in the examination process to deal with the temporary desalination plant, but it also covered wider matters to do with water. And at this hearing, the NWL was represented by legal counsel. And so there was an opportunity for their view to be provided as well. And as we noted then, we noted, the judge also noted, if one looks at the bottom of page 62, paragraph 1.2.6, we recorded what we'd said there, 3 lines up from the bottom. Accordingly, even if NWL cannot identify a source now, they are obliged to do so and plan so as not to allow water supply to constrain growth. NWL's confirmation of that today was helpful. That's referring back to something they said earlier. And at the top of the page, following, in response to an invitation from the examining authority, I interpose there, following the submissions that I had just made, to comment on those submissions, NWL helpfully made clear it did not take issue with anything that I said. So that was not only said in the examination hearing, but then recorded in writing afterwards, and no one's taken issue with that. That reflects what happened. So it's not just the applicant saying this. NWL saying, yes, that's a correct understanding of the ultimate effect of the regulations, the Water Industry Act and the relevant guidance. And we say that the key flaw, therefore, in the examining authority's position, which the Secretary of State corrected in the decision letter, was that it failed to understand the intended relationship between the planning system on the one hand and the water resource management planning system on the other, established in the Water Industry Act 1991. In short, what the examining authority's approach seeks to do is to reverse the intended operation of the system, so that the water resource management plan would have to lead. And the planning system has to wait until that process has been completed before it approves development that will create demand the WRMP must meet. That is to put the cart before the horse.
So they were wrong to say that you couldn't, that they were recommending, because you couldn't, the Secretary of State couldn't carry out his obligations. They could have carried out the obligations, but you accepted the matter of discretion had they decided to wait and try and do stage 1 and 2 together rather than do stage 1 and then do stage 2. That would have been all right, but to say you can't do stage 1 unless you have the information relevant to stage 2 is a legal error.
It is an error, and it fails to understand the way the system is set up, because the duties that are established through the Water Industry Act on the undertakers involve using their plan to provide the water that's needed to supply the growth that's been identified, and identified in particular through the planning system. And the guidance makes clear they should avoid constraining planned growth.
Do you say this was a legal error, or an error of judgment short of irrationality?
I don't go so far as to say that there is a rationality issue.
No.
But I wouldn't
The
want to...
misdirection in law
It's
is
a
the way
misdirection in law.
of the legal framework.
they could have, as a matter of discretion, decided we would prefer to do 1 and 2 together, but they are saying we can't do 1 until we have 2.
And that's a mistake.
That, you say, is a misunderstanding
Yes.
of relation.
Is
That
that-
is illegal.
Is that really what they're saying? What was the reference again?
1 and 3.
It's in the supplementary bundle.
Just wonder whether they're going quite as far as to say that. Is 10.3.1 more than an evaluative judgment? After all, you don't need to be saying that they made a legal error.
For my purposes, I don't need to go as far as to say that. But what I do say is that insofar as this is said to be something which is compelled by operation of law, first of all, that's not a correct understanding of the way that the HRA works. But secondly, it fails to understand that the system is set up to avoid this very problem. It's not a problem.
So at the very least, it's not irrational to take a different view. I mean,
Exactly. The Secretary of State got it right, we say. But even if the examining authority could potentially have defended their position as being rational, at the very least, the Secretary of State's deciding that effectively we're right in our understanding of how the system is meant to operate, and making a judgment. This is not part of the same project, and that it's not necessary to assess whatever the water supply solution might be. It's a rational decision in itself. And the planning policy, whether that's development plans or whether, as here, we've got a site-specific MPS for a water-using development, those aren't inputs to the WRMP. I don't say and don't need to say that there isn't a need as part of the planning decision to consider what the implications might be for the WRMP, and that's done here, and that's fine. But if one looks at the guidelines, and I put this in yesterday because they're referred to in the documents, they're referred to in the judgment. I hope they've gone in at the end of the authority's funding. The extract from the guidance that refers to not constraining growth, phrase court will have seen. And it's in section 6.3 of the guidelines. Just for clarity, the version you've got is the most recent version, which the Secretary of State referred to in the decision letter, but it's the same point.
So we're looking at
6.3. It's headed forecast population, properties and occupancy. So this is a stage of the assessment.
Yeah. So this is in the Water Resources Planning Guideline.
Yes. This is what we referred to during the examination to the Secretary of State. It's also referred to in the decision letter. The guidance is referred to page 369, footnote 7. But what that document says, and one can see just from looking at the first few paragraphs here, your planned property and population forecast for government supply must not constrain planned growth. For companies supplying customers in England, you should base your forecast population and property figures on local plans. And then it goes on to explain in more detail what you do if you've got emerging plans and what you do if you don't have a plan, all the rest of it. And then underneath the bullet points, where your area includes major strategic housing and growth developments, such as, and give some examples, you should include an estimate of the planned growth in the baseline, and then talks about how you go further. These are inputs. The planned growth, whether it's in a development plan, whether it's a garden community, whether it's a nuclear power station, will depend on the WRMP to deliver its water supply and to assess the effects of doing so in the same way as, in this case, for a development which has the benefit of a site-specific NPN.
I may be being very slow, but I just wonder about this. If in reality Sizewell C Ltd had to wait for the water supply solution to be resolved, because ultimately that was preferably and indeed actually going to depend on the actions of Northumbrian Water, you would have to do an assessment, and the assessment would have to be a cumulative assessment. And what is the real difference in terms of delay? You say that it's the process that has to be resumed after that.
But it's, if I may say so, Lord, one can work through the consequences partly by looking at what happened here. I'll go to the references in a moment. But your Lordship may recall seeing in the papers, and I'll go there in a second, the current WRMP, the 2019 one, does not include Sizewell C. We said
no,
it should go in there, but they said, well, there's planning uncertainty, effectively, because at that stage, the National Infrastructure Commission said, well, there should only be one nuclear power station. So NWL had taken that as an excuse, said, well, we don't need to build that into our assessment. We then get to a position where they agree to put Sizewell into their assessment for the 24 WRMP from 2032. So they identify a date at which point the construction will have been completed and commissioning of Unit 1 will have started. So that's when they need to supply their water.
Yeah.
So when they're looking at their plan and they're working out how much water we've got at different times, they know with 2032 they need to have Sizewell ready. But that's because there's an application. An application then generates a likely date for decision, generates a likely date for starting construction. That generates 2032. If you have to say, well, you have to wait, what does the WRMP work with?
The waiting is real, because you can't get started until the process has been resolved.
And you can't generate a date for construction until you know when construction is likely to start. You can't know when that's going to start until you've got a date, likely date
So
for
it
the
does. So
decision.
it is truly incremental upon the second process coming first.
Yeah. It really does put the cart before the horse, and the length of the delay is considerable.
Yes, to use the well-worn image of the cart before the horse, it's the whole cart, not just part of the cart.
Yes.
Is that right, or it's the whole horse? Yes.
It's a wagon train. not
Yeah,
even a
but the
car.
point you're making,
for a
the simple point you make here is that going about things in the way that is suggested on the other side would cause real delay to a nationally significant infrastructure project. That's the point.
It would certainly do that. I say it also has implications more widely, because it's not, the principle doesn't just apply to us. It applies to the housing scheme, whether it's 500 houses, 5,000 houses. They all feed into this, and they all generate dates by which supply has to come on the street.
Yes.
But I mean, ultimately, we have to understand what the law is and how it applies in the present circumstances. I mean, that's what we are here as the court to do.
Indeed. But my simple point, my lord, is that insofar as the claimant seeks to derive support for its rationality challenge from what's said in the examining authority's report, we say at the very least it was rational for the Secretary of State to take a different view. Indeed, I go further and I say the answer to the examining authority's concern lies in the system that's been set up.
Can I just check, are you also submitting, or does it not go that far, that not only would there be delay and so on, but that the water people could turn around and say, you still haven't got a date, and we're not putting it in until you've got a date? Oh, right, so it's as far as bad as that, is
Well,
it?
it makes their life obviously easier if they don't have to plan for some particular.
And they can say, well, I'm sorry, you are stage one, we're not doing stage two till you've got stage one. So each of you will be sitting there
well,
waiting for the other to start.
Indeed, and this is the point we made in, I promised I would give the reference. It's in the supplementary bundle. It forms part of the submissions we made following issue specific hearing 11. And it's on page 42 going into page 43. Paragraph 1.1.47. I just allow the court to.
Yes, it's the certainty of the date point, by definitely
Very
pushing
quickly,
it
just
back.
Yeah.
And we were pushing for inclusion, and they said, well, there's uncertainty caused by this issue about whether the current policy, the national policy statement, is to prevail.
Well, this is the point you just made, isn't it?
Indeed.
Yeah.
And if my learned friend has helpfully just reminded me to bring to life, as it were, the point about timing. If I can just direct the court's attention to page 298 of the supplementary bundle. This is within the draft plan that was put out in December 2022. This relates to the blind water resource zone, which is the water resource zone in which we sit. Just to illustrate it, one sees here in this graph the point at which Sizewell C nuclear power station demand comes on the stream. That is in a context of a graph that is looking at, and one can see from the key, total water available for use. I think that's what 1 means as the orange line. And at the bottom, one can see on the axis the years. And then in the vertical axis, the amount of water. So they need to know what's happening when the plan. That just illustrates how that happens in the future in the current plan. And Mr. Wolf seeks to answer this by saying, well, effectively you have some sort of mini WRMP process within the examination of the power station. Well, one only needs to look at the position as it stood at the time. I can ask you just to go to tab 8 in the supplementary bundle. This is the NWL letter of 23rd of February 2022. page 76, paragraph 8, which identifies the options that are being appraised, not just these. These are, in particular at C and D, these are types of option. They're not project options. So effluent reuse is effectively a technology type. It's not saying effluent reuse at this location or desalination at this location. Longer use winter storage reservoirs, but where? And just to further illustrate the sort of process, I can do this, I hope, really quite succinctly. If one turns on in the bundle to tab 22, to page 249, this is later in time, of course, so this is post-decision. This is more information, November 2022. But on 249, one sees the option types initially considered set out in a bit more detail, but as types, not as projects, and then also demand option types, which my learned friend referred to, that were considered. So very, very broad at that stage. And then to understand how that then converts into a plan, get some sense of the process. If one goes to tab 23, page 281, this forms part of the contents pages of the plan, the draft plan put out at that stage. Just by skimming, well, 279 through to 282, one gets a sense of the complexity of the process. In a sense, I don't need to go further than that to illustrate, frankly, pointless it would have been to attempt that exercise in parallel through the development consent application for an individual infrastructure proposal. What possible use would that have served in making a sensible, informed decision? And then finally...
This is your third point now.
Well, I think, my Lord, in terms of the time, I'm going to make my third point very quickly. If I may, I'm just going to use my time to just deal briefly with the way the appellant puts it. In the skeleton argument, it said we should have committed to and assessed. Committed to and assessed desalination. That's paragraphs 45, 51, 54 and 77A.
Sorry, give me the paragraphs again.
45,
yeah.
51,
yeah.
54 and 77A. Commit to it and assess it, because they recognise that when it's unlikely, when we haven't committed to it, it's pointless. We point out in the skeleton there's no authority for the proposition that we've got to choose something that we don't want to do, that no one wants us to do, we don't think is necessary to do. But then in oral submissions, my other friend changes tack and says, well, instead of doing that, assess it and potentially refuse on the basis of the cumulative effects of the desalination, which we're not proposing. Well, there one does see straight away a legal problem.
Yes.
We are proposing a strategy which is different.
Yes.
And we're going to be refused permission on a different strategy that we're not proposing, we don't think is likely. That at the very least raises a rationality point. And then the third point I would make very, very quickly, and that's the significance of NWL having included our operational demand in its emerging WRMP from 2032. And the significance of that is that in identifying that demand, in its forecast, it is accepting that this is something that forms one of its obligations under Part 3. And that one can get from 37A, subsection 3A. It is required to estimate the quantity of water required to meet its obligations under Part 3. It's decided we form part of that obligation. So when Section 55 is part of Part 3, it's decided it's going to plan for that. So when one looks at the caveat in subsection 3 of Section 55, it's through that lens once we've been built into the forecast demand. So I'm slightly over my time, but those are my 3 points. I hope that's helpful if there's anything else.
Anything else, John? Thank you very much, Mr. Perry. Thank you. Yes, Mr. Wolf, your reply.
My Lord, I'm very grateful. Can I start, if I may, with Mr. Philpott's points, and indeed take them in reverse order. So first of all, his points about the Water Resources Management Plan and its relationship with the other processes. He helpfully took you to the post-decision materials, which indeed the judge also looked at, that's in the back of the supplementary bundle, in which you see, and I won't take you to it, that the water company is already in the process of assessing the environmental impacts of the various potential options, including the potential options to deal with the problem created by Sizewell. Yes, they say we need more detail. I won't take you through the detail, but they have already identified that there are potential SAC impacts, including arising from the particular components which, as far as we can see, are Sizewell related. So this is not some future process, it's happening now. Nobody, we are not saying that they need to commit, this is the water company, to building those things. Planning for them is not the same as building them. All we're saying is what's in play here is assessment. So in terms of the examining authority's position, assessment, not necessarily a full plan, and by no means constructing what you might not then need. Second point arising from Mr. Philpott, the permanent desalination plant. He took the court to page 100, which is in the examining authority, supplementary bundle, page 100, I should say, in the examining authority's report, where they bring together the outstanding issue materials, and that's the paragraph in which they reach the conclusion this is so important as to need to be left over. That refers the reader back to section 5. In section 5 is a very important paragraph, 5.11.292, that's on supplementary bundle, page 95, where they contemplated at that stage there remains a possibility that the proposed development may not be able to operate. They contemplated the possibility, the risk of no water supply coming out of the NWL process. That is fundamental to the consideration of this project, because without a water supply, there is no electricity being generated. And the electricity is what gives this project its EROPE. There is no EROPE in building, to use my Lord Justice Lewis's phrase, a gleaming power station on the Minsmere coast. The value here is in the electricity. So they were rightly contemplating the possibility that the EROPE would be thwarted by the lack of a water supply. That is the context in which the Secretary of State asked those questions, 3.3 and 3.4, not out of a side interest in desalination, but because it potentially offers the solution to that problem seen by the examining authority. And the answer to that question, the questions, namely we could build a permanent desalination plant, was then fundamental to the Secretary of State's reasoning. Page 368, paragraph 4.44.
368, yeah.
4.44. Secretary of State considered the response to the questions, sets out the various water, the NWL options, and then says, Secretary of State considers that these represent potentially viable solutions, as would the fallback of the desalination plant. The Secretary of State is therefore content that if consent is granted for the development, there is a reasonable level of certainty a permanent water supply solution can be found. So the desalination plant is not some peripheral question that's just arisen incidentally. It is fundamental to the Secretary of State's reasoning in reaching the necessary certainty that the plant can operate, and therefore the very EROPI which has justified the power station in the first place. And it's in that context that the desalination plant is absolutely central to considerations here. It may never be what anybody wants. It may not what the applicant wants, but it's part of the Secretary of State's necessary reasoning. The Secretary of State makes the desalination plant material to the considerations. The difficulty then, when we look at the Secretary of State's decision...
So why isn't he required to do an assessment of nitrate removal, effluent reuse, and winter storage reservoirs, because they might also be...
Just to pick up my learned friend Mr Philpott's last point, we have not said, we do not say that they need to do an assessment and commit to building the desalination plant, nor do we say that what should have happened here is, to pick up his very last point, an assessment leading to a refusal. Our point is that the solution to their dilemma was in their own hands. And indeed, the solution to what I say is the legal problem, which I'll come to in a moment, was in their own hands.
So they're only required, if there's the possibility of being open, they are only required to provide an assessment of something that they might actually be able to do to prevent it not opening.
No, it's not that they're required to do it. We're not saying they're required to do it. What we're saying is that's the solution to the problem they've got. We're not mandating it, but what we're saying is, that's a very important point, we're not saying you needed to do that, but if you wanted to avoid the problem, which the examining authority identified, Secretary of State gives you a step on the way to that, which is cover off that risk by permanent desalination plant. It thus becomes part of the picture through the Secretary of State's lifeline throwing, if you like. At that point, they don't have to assess it, but if they don't want to assess it even then, they've then got a problem of their own making, which is there's no assessment of the total impacts of either the project or the cumulative impacts, and I'll come back to why that matters in a moment. And if we then go to the Secretary of State's decision letter, which you've seen several times, I know, but where the Secretary of State deals with desalination plants, it's page 373 of the core bundle, paragraph 461. The reason the Secretary of State says I don't need a proper assessment of this is because it's not their proposal and it's not what they want to do and it's unlikely to be necessary. All of those are factually correct. The problem is the desalination plant is the thing which is providing the backstop to allow the Secretary of State to say I'm confident the power station will be built and therefore to generate the EROPI. Now, the developer is entitled at that point to say, well, we're not going to assess the desalination plant, we don't want to. Then they've not taken the lifeline from the Secretary of State, they're simply back in the examining authority's position. If they want to, though, and that's our point, they could have provided, and had they provided, the Secretary of State could have assessed an assessment of the desalination plant. Not necessarily, see Mr Philpott, leading to a refusal, entirely possibly leading to a consent, because the Secretary of State would have been able to take into account the impacts of the power station and the impacts of the desalination plant as a possible option, and say, taking those into account together, I ask myself the habitats question, how many marsh harriers, etc., and the planning balance question. And if I still reach the conclusion that the habitats is okay and the planning balance is okay, grant the development consent. But you've taken into account the impacts of the necessary water supply.
But this seems divorced from reality. It's nothing to do with assessing from the public perception what's likely to happen. You're saying to these developers, if you spend enough money and do something that nobody thinks is going to happen, but if it does happen, they cover it off, you do that, I'm going to give you the consent, and it might have no relationship at all to what's needed to know whether the plant is a good thing or a bad thing.
Okay, let me take my lord then into the second submissions, which is the submissions arising from Mr Strawn, given my limited time. Mr Strawn rightly says that we accept this as a Wednesbury, as a rationality question, but when I answered that question from my lord senior president yesterday, I made very clear that that discretion has to be exercised lawfully and consistently with the Habitats Directive. Make that point in the skeleton and so on. And the habitats problem is the one that I spent some time on this morning, the two limbs of paragraph in our skeleton argument, paragraph 74, and we then link that specifically to the Habitats Directive in paragraph 78, 79. It's partly, but only partly, the possibility that permission for the water supply is inevitable, the overbearing point. And I do maintain that proposition, in part because the Secretary of State has assumed that outcome. Refer back to what I looked at a moment ago. He has assumed that one way or another, a water supply will be consented because that's the basis of his EROPI calculation. So he's assumed some consent will be granted. So I don't think I'm on sticky ground in making that assumption, but that's not the real issue. The real issue is the one that my Lord Justice Lewis has characterised a couple of times, and I will forget exactly the words you used, which is we consent now to this amount of habitat damage. We then come along later and consent to the thing which is necessary to bring out the benefits of the first bit. And we realise that if only we'd done the assessment at the same time, we might not have consented to the first project at all. And there's a
By
number
reference
of...
to something that isn't part of the plan at the end.
I'm sorry, my lady?
By reference to something which on this hypothesis is not part of the overall plan for the development at the end
Sorry,
anyway.
I'm clearly not explaining myself well. What I'm talking about is the habitat's risk of
I
the
think
approach...
I think you are, Mr. Wolfe, with respect. I think you are. What you're saying is you consent now to the damage that's already there from the power station alone. And then if you consent later, there might be damage caused by something other than a desalination plant, for example, building in a big pipeline. And that might cause irrevocable damage to second site for a marsh harrier, I think my Lord's point. And therefore, you then say to yourself, well, if we'd done it all at an earlier stage, the power station might not have got the go-ahead. But on your whole own case, what you would have done at the earlier stage is assess the habitat's impact, not by reference to the actual project, which is the plant, which is the pipeline, but something completely different, which is not part of the process at all. And I'm afraid I just don't follow the argument.
The important aspect of there's two evaluations going on here, the Secretary of State's decision. One is the habitats evaluation. Mm-hmm. Is there a risk, adverse harm to a protected site, leading to alternatives, leading to a ROPI? And in parallel with that is the planning balance question. And they both potentially lead to a refusal or an approval. And what we're saying is that those evaluations need to be done lawfully. And one way of doing them lawfully, not saying it's mandatory, but one way of doing them lawfully would be to include the impacts of a water supply solution so that you can do the planning balance based upon an understanding of what it would involve, including a water supply solution, and so that you can do the habitats assessment on the basis of what it would involve, including a water supply solution. And
But
if
a different
that
water supply,
Sorry?
or potentially a different water
but
supply,
but that's how that. Sorry, I went around this morning. I've not got much time. That's how the habitats assessment process works, because it requires you to do an assessment. If you cross the threshold in Regulation 63(1), you have, and therefore you're into 64, you have to look at alternatives. And if there's a better way of doing what you're proposing, a less habitats intrusive way of doing it, you're forced to do it that way. But there's nothing to stop the developer coming along, if it wants to get itself out of this fix, to make the Habitats Directive work, and I'm going to come to the Habitats Directive in a second, assess the desalination plant, which is part of what the Secretary of State contemplated to get you out of the EROPI fix. If, on the basis of that, let's call it a worst case, but it's at least a real case, you can get your permission and your habitats consent, as it were, go ahead, right? If later you come along with another option, a pipeline, which is better, nobody will complain, and you will get through this Regulation 63, 64 process, because let's say you come along with something that does affect some marsh harriers up the track, so you are back in 64 territory. In that 64 territory, you say, are there alternatives? Yes, there are. There's the permanent desalination plant, but that's worse. So we can't be made to build that. That's how the Habitats Directive and the Habitats regulations work. Routinely, that's how they work. They're about finding the least intrusive way of doing the development in terms of habitat site impacts. And there's nothing in my submission controversial or problematic about any of that. We don't say they had to assess the water supply. I want to get that out of your heads. That was one way out of the problem in which this decision-making process left them. We feel sorry for them, but they were left in this position. One way out of that fix would have been to assess the permanent desalination plant. The Secretary of State could have taken it into account. In terms of how and why the Secretary of State doesn't take it into account, it's 461. His only reason, and I generously said let's treat that as part of the project question, but it also seems to be part of the cumulative assessment question. It's the only place where he asks whether I'm going to include it in the project or the cumulative assessment, and the basic answer is it's not what they're proposing, and it's not part of the application. Now, that's an Ashchurch error. That's an Ashchurch error. And it's not an irrelevant Ashchurch error, because it can't be, as it were, pushed to one side in the way that Mr. Philpott would have it, because it was part of the Europe calculation in the first place. Can I then just, I appreciate time is running on, pick up the habitats point? I do ask you to go back and look at Champion, and then Wingfield number 2, as we've called it. That may be the wrong number.
Yeah.
Champion takes you through the key European cases, Vardensee and Sweetman, and makes the point that you have to have, because of the precautionary approach, you have to do assessments which exclude the possibility of adverse impacts, or next stage down, give you a clear view of what they are. Interwalloni then says, aim to do that as early as possible, if you can. But that sits within the Wingfield, Ad Astral, etc. line of authorities, which remind us, back to Vardensee and so on, that you can have a staged process, and you can assess, you can leave assessments till down the line, but what matters is you don't consent to the development until you've completed the assessment. You can do it in stages, but you don't consent to it till you've got the full picture. There is no mandate in the Habitats Directive for leaving things over just because they're hard to assess. The Habitats Directive requires you to complete your assessment process and reach that conclusion. And it's different to EIA because it drives yes-no answers. It's not merely procedural. And that is absolutely fundamental. And when we then look at that in the context of all the things that Mr. Strawn said about the Planning Act, NPSs and so on, NPSs, habitats assessment, absolutely clear. But they're without prejudice to the next habitats assessment, and most importantly, they don't give you consent to do anything. You cannot pour concrete off the back of an NPS. When you then get to the DCO, I mean, as it happens, this wasn't a case. I mean, I don't think Mr. Strawn meant to suggest otherwise. This wasn't a case to which NPS 6 applied directly. It was a Section 105 case, not a Section 104 case. But even if it were an NPS case, Section 104(7) is very clear in saying you still balance harms and benefits. And of course, the Habitats Directive still applies. And just to go back to particularly the harms and benefits thought, while I've got that in my head, that is absolutely what happened here in relation to the downstream water processes. They've taken into account the benefits of a water solution. Go back to what I said about the Secretary of State filling in the Europe point, without taking into account the harms. And that's part of, clear in our skeletons, part of our skeleton argument. But the NPS doesn't create a development consent, doesn't allow you to pour concrete. Only the development consent then does. What is then being contemplated is, in effect, splitting the necessary components of what's needed to make this electricity, which is power station plus water, into 2 stages, and assessing only part of it at the first stage. thus creating the risk that my Lord Justice Lewis was talking about. And that's what the Habitats Directive does not allow you to do. It does not allow you, in effect, to authorise the project on a basis which means we might come along later and realise that only if we'd only assessed this completely now, we wouldn't have granted permission in the first place. And then there are two ways of looking at the second stage. There's the definitely grant it and the maybe not grant it. The definitely grant it is what I've just been talking about. It will definitely be granted, and that might bring about impacts which, had they been realised earlier, would have been fatal. If they don't grant it, though, picking up Mr Strawn's possibility, he says, can't be assumed. Let's say they wake up one morning and say, we're not going to grant permission for any water supply. We then have the gleaming power station, which may have many other objections to it, but one of the objections is it's a Habitats Directive absolute breach. Because you've allowed something, a power station, which you've built on an SAC, creating habitats harm, assuming an EROPI, which was dependent upon something which you didn't then secure. And that's why the connection between the two is so fundamental. It's not just about, as it were, we need water. It's about the legal, analytical, planning connection, habitats indeed connection, which chains you back. And that's why when we look at Larkfleet, Mr Strawn, sorry, do I mean Larkfleet? I mean Forest of Dean. Sorry, Forest of Dean.
Right.
Mr Strawn was keen to say to you, well, those passages are not dependent upon what Lord Justice Sales said of the interdependency point. But with the greatest respect to him, they are absolutely dependent on the interdependency point. What he was looking at there was a situation in which there was no harm at stage one and no interdependency. And he says that's unproblematic because you can pick it all up at stage two. Our facts are different in two ways. Harm at stage one and can't be ruled out at stage two, and interdependency. And that creates the absolute possibility of either a gleaming power station that can't be operated, that should never have been built because there was no EROPI for it, or a realisation that you've caused harm that if only you looked at it at the right time, wouldn't have led you to grant the permission for the power station. And the Habitats Directive, the Habitats Regulations and the case law, my submission make that absolutely clear. You cannot leave things down the line beyond the point at which you grant development consent. And that's the critical thing.
Right.
Lord, I think that may be it, my Lord. Those are our submissions.
Good. Thank you. Are you sure there's nothing else?
No, I think that's it. Those are the big points.
Thank you very much. Well, thank you all very much. Mr Strawn, you look as if you're about to say
I hesitate because I don't want to stop you from rising, but
No.
you did leave over the question, the procedural question, cost protection for determination.
Yes, that it seems to us is not a matter for us at this stage anyway.
Well, I was going to say that it seemed to me that, bearing in mind we've had the hearing and all costs have been incurred, that determining the application to vary the existing protected costs order won't be prejudiced if it's dealt with as consequential matters. But
Isn't it worse? I mean, doesn't the rules say that it's got to be a single judge who decides on the papers or refers it to court, not three judges in court?
Well, I wasn't getting... Well, my understanding also has to be necessary because the proceedings wouldn't otherwise take place, but they've already taken place, which is another problem.
Yes.
But leave aside, I wasn't intending to get into the...
Whether or not there is actually a procedural obstacle, which I suspect the White Book would answer if you looked at a particular passage. It does seem to me to be right to say that that is not a matter for us to consider at this stage. That seems a safe statement to make.
I only just raised it because of the...
Does anyone dissent from that?
No, it also slightly depends. Now we're here, slightly depends on the answer the court gives.
Of course.
Right, we weren't going to push that.
Process about what we do in this one. Do you mind?
No, please.
As I understand it, Lord Justice Coulson has given permission to appeal, and we are deciding that appeal whether or not Mr Justice Holgate erred in law by not granting permission. But in fact, were we to decide that it was arguable, we would also retain the JR rather than send it back. We've had all the arguments, and we would decide whether to grant or dismiss the JR as well. That's the route by which we're going. It's talked about as a rolled-up hearing, but there is no such thing described in the White Book. And that's what we're doing, is that there is an appeal on the refusal of permission. If we allow that appeal, we retain it, and we have already dealt with it.
My Lord, I have no issue with that. This was simply about varying the protection.
No, this is the second thing.
This is separate and different question.
I moved on.
I'm so sorry.
I'm so sorry, I should have made it clear this is my point too.
Nobody's asking this point. I don't know what to do. I'm causing trouble now.
Sorry. Yes, fine. I agree with that. I agree entirely with that analysis.
Not necessarily the analysis, but because it came quite quickly. But Mr. Strawn's point that this is not for now, I do agree with you.
No, this is my point is a different point entirely. It's got nothing to do with costs. And
what my Lord said about the nature of the hearing, we've just got is our understanding too.
It's your understanding as well.
I'm so sorry. I'm sorry for setting this hair running. All I was doing is that the court had alerted us to the need to deal with the application to vary the protection.
I know, and we dealt with that, and I moved on, but without pausing for breath.
I'm so sorry.
But having moved on, do you agree with where I got?
I absolutely do agree with,
that's all
with
right,
that analysis. It was the protected cost order was the only
It's
thing.
a separate issue, yeah.
Are we all agreed on that?
Yeah.
I think we are.
I think I said that at the very beginning, and nobody shouted at me.
Well, I think
it was like the first thing I said yesterday.
You said rolled-up hearing, which is not quite the same.
It took a little bit of time to dissect what was meant by a rolled-up hearing, because there was an order that granted permission, and of course you generally think of rolled up in the context of permission hasn't been granted, but of course it's permission in relation to a permission to proceed with judicial review. And I think that ultimately rolled up is being used in a slightly different context.
I think it's the code.
Yes, if there has been a jurisdictional solecism, then we have now resolved it, I think. I hope, but in substance, I hope that that is an agreed understanding of what we have been doing for the last day and a half. As to which, thank you all of you, and I mean all of you, and those who sit behind you and assist you, for the great care that has been devoted to the preparation of these arguments, both written and in their presentation oral. Thank you all very much. You've given us plenty to think about. We shall reflect on our decision. That will emerge as a draft judgment in due course. At that stage, as everybody familiar with the process will be aware, we will be considering only typographical or minor factual corrections, nothing more than that. At that stage, too, a draft order should be prepared and presented by counsel, together with any consequential submissions, which will be dealt with at that stage. In the meantime, pending the handing down of judgment in due course, the normal embargo arrangements will apply. They are to be strictly adhered to, and there may be consequences if they are not. Thank you all very much.
Before you start, David. Well done, that was really excellent. Well done. Basically, yeah.